Okay, I think we're good to go, Corey. Um, so, look, I've put a bio for Corey in the website as well, but suffice it to say, a wonderful barrister working in black chambers, who has done a lot of work in this space, but also academic work to write about some relevant new legislative change. But also, you'll see that Corey's done a couple of postgraduate qualifications that really make her a lawyer who's extremely well informed about the mental health system, who has worked in and around some of the research teams that uh, Liz has as well. So thanks for today, Corey, and over to you.
Thank you. Can I just check you can hear me okay?
All very good, thank you.
Okay. Before I begin, I'd like to acknowledge the traditional owners of the lands on which we all meet today. I also would like to acknowledge the traditional owners of the land I'm presenting from, which are the Gadigal people of the Eora Nation, and pay my respects to elders past and present. I also would like to pay respects to the elders and First Nations students that are present today. Before I start, I just would like to acknowledge the invaluable work that Dr. McIntyre has done in this area, and I'm looking forward to seeing the results of the diversion research. So in terms of today, I was asked to present on some of the issues that lead to a person becoming a forensic patient and into the forensic mental health system. So if, Mark, sorry, if we just go to the next slide.
There we go.
So what I propose to do, and I'll try and go through it so there's some time at the end for questions, is just to go through some of the relevant definitions, which you've already heard Dr. McIntyre explain some of the processes, so fitness, and then the defence of the mental illness defence, or the leading to the finding of act proven, not criminally responsible, some brief reflections, and then some time for questions. Thank you. Okay, so just you'll obviously come across mental health and mental health issues in law, particularly relevant to crime in a number of different ways. For fitness, so that's fitness for hearing, in terms of potential defences, so the partial defence of substantial impairment, making murder to manslaughter, the complete defence, what previously used to be known as NGMI or called NGMI is now APNCR, which is act proven not criminally responsible. And then sentencing, it comes up as well in terms of moral culpability and risk. And then local courts in terms of diversion, it can also be relevant. Next slide, thank you. So some key terms, and you'll probably hear your next speaker describe in more detail about concepts like detained person, involuntary patient. So that's normally the terms we use for people in the community where they're detained or scheduled, and then they become, in some cases, an involuntary patient after review. In New South Wales, remarkably, we're one of the only states in Australia, let alone the Western world, that has a concept of involuntary patient in jail. So that is, however, used less so, I understand, more recently, and is probably on its way out. So correctional patient, that's a reference not to be confused with forensic patient. It's talking about someone that is like a remandee or a prisoner, like a sentenced prisoner, and they then are scheduled, and it's like an involuntary patient, but they're a correctional patient. The other term is forensic patient, and Dr. McIntyre already set out the difference. You'll see they're limiting terms. So those are the people that have become unfit, or they have a fitness hearing, and then it's determined that they are unfit. And then what happens is they have a special hearing, and then at the special hearing, if they're found guilty on the limited evidence, then they are given, if they would have otherwise received a custodial sentence, they're given a limiting term. And that limiting term is usually served either in custody or like a hospital, like the forensic hospital, but they can still be ultimately released on conditional release by the tribunal and serve the remainder in the community. The difference is there's no sort of parole period per se for limiting terms like there would be for a sentenced prisoner. The second kind is the forensic patient that has asserted a mental illness defence, and has been found act proven not criminally responsible, and they're a forensic patient too. And both of these types of forensic patients will, as I said, either be in custody or in a facility like the forensic hospital or perhaps a medium secure unit. But normally with the second kind, they remain a forensic patient indefinitely until the tribunal ultimately unconditionally release them. So that can take some time. Whereas the first kind, the limiting term is for the period that the court sets. So for 3 years, for example, at the end of the 3 years, that term will end. They'll cease to be a forensic patient unless there's an application to the Supreme Court to extend the forensic status. And then the third concept is like remandee, person waiting to have their trial and then sentenced. Next slide, please. So the other things that when you're working in this area that you'll commonly see common diagnoses and conditions, and they're important also because they factor into when you're looking at the definition and whether the Act applies to someone. So serious mental illness is often used, but often what is meant by that is schizophrenia or a very serious psychotic disorder, and those types of things. And then complex PTSD is often present in a lot of these cases that I've dealt with, particularly where there's been a past history of trauma. Intellectual disability and cognitive impairment. Sometimes people use those words interchangeably. Intellectual disability, however, is more about having that disability before the age of 18. And then personality disorders are also often present, and that could be like antisocial personality disorders or borderline personality disorder. And then comorbidity, often with substance use disorders as well. So these are the common diagnoses you'll see, and that may be relevant when you're looking at whether someone falls within the provisions of the Mental Health Cognitive Impairment Forensic Provisions Act or the Mental Health Act. Next slide, thanks. So again, just to forensic patients, we've just gone through that. 2 types, limiting terms and the ones that receive the complete mental illness defence. Next slide, thanks. Okay, so firstly, just in terms of in New South Wales, obviously we have the local court, district court, Supreme Court. Often murder's only ever dealt with in the Supreme Court, but in the local court, we don't really have fitness hearings or this type of thing. So normally what it is in the local court, mental illness or can be relevant for diversion, for example, or to sentence. It's often relevant to sentence. With diversion, we call it a Section 14 now. It used to be a Section 31 or 32, I think it was. But under the Mental Health Cognitive Impairment Forensic Provisions Act, which came in 2020 and made some changes, it's now Section 14. And so what that says is that if a person does have a mental illness or condition or a cognitive impairment, that they may be able to be diverted. And I've just set out the section there, but in the interest of time, I'll go through to the next slide. But it's important to be aware that the 2 concepts in this legislation that we're dealing with is mental health impairment and cognitive impairment. And so for the purpose of the definition, cognitive impairment will include intellectual disability and those types of things. Okay, so who's eligible? Here we go. Orders are only available in summary and criminal matters. So you can't get a section 14 in the district court or the Supreme Court. In the district court or the Supreme Court, that's when we're looking more at whether the person is fit at the time, and whether they may have a mental health defence, or whether they might be fit at the time that you're representing them, and but they may otherwise be entitled to a mental health defence. Okay, Mark, sorry, next slide. And that's just the important conditions are now set out as to what the magistrate can consider when deciding whether to divert someone. So obviously they have to have the mental health impairment or cognitive impairment. They have to look at the seriousness of circumstances of the offence and the suitability of the options. And what that might look like if someone gets that is with the treatment plan is if they're in the community, they may have a healthcare provider that has written out a treatment plan that they can implement to support that person, rather than that person being dealt with by law in terms of being sentenced. Now, interestingly, Dr. McIntyre's research around diversion might reveal some answers, but in practice, what happens is if you can't have, some courts have allocated justice health and nurses where you can get a sort of court report, but if you're not there or you need to get a report, if the person's legally aided or represented by Aboriginal Legal Service, there can be some difficulty in terms of funding to get the report, and that may also contribute to people not utilising this option or applying for this option. Next slide, thanks, Mark. So mental health impairment. So the key thing, the definitions contained in Section 4 of the Mental Health and Cognitive Impairment Forensic Provision Act. And it just I've set the definition out as per the Act there, but the important things to note is it can include a temporary or ongoing disturbance of thought, mood, volition, perception, and memory. And it's got to be significant for clinical diagnostic purposes. The disturbance also can impair the emotional well-being, judgment, or behaviour of the person. And then in subsection 2, you'll see it specifically sets out other reasons: anxiety disorder, affective disorder, psychotic disorders. And you'll note there, which is a controversial one, 2D, a substance-induced mental disorder that is not temporary. And then you'll see the caveat 3, a person does not have a mental health impairment if the person's impairment is caused solely by A, temporary effective ingesting a substance, or B, a substance use disorder. Now that comes up quite a lot, where someone, for example, might not necessarily have any prior diagnosed mental health impairment, and then in the course of using substances, develop some kind of psychotic disorder, and whether this applies to them or not. So you'll see quite a few cases now, particularly since this Act and the definition has come in around that particular 2D and 3. The other thing to note from that definition is it's not there, but personality disorder. The Law Reform Commission, before this Act was introduced in 2020, made recommendations to specifically exclude personality disorder, and they didn't take that recommendation up. They haven't referred to it, but so what you can take from that is it's not excluded. Next slide, thanks, Mark. And so the other in the definition of cognitive impairments in Section 5, so you're looking at Section 4 and Section 5 are the key ones. And the important thing to note about that is that prior to this Act coming in 2020, cognitive impairment was only provided for in the diversion, the equivalent of Section 14, the diversion one. So now, I mean, this is good. This recognises in appropriate cases that cognitive impairment will be included. Next slide. Thanks, Mark. Okay, so the other thing that our Act now does that the previous one didn't is it codifies the fitness test. And you'll obviously come across in your studies the Presser test, which was the test at common law. Well, that's now codified in section 36 of the Act. And that just sets out there what the test is. So basically, the person is taken to be unfit to be tried for an offence if they have a mental health impairment or cognitive impairment or both, or for any other reason cannot do one or more of the following. And they're set out from A to I there, but understand the subject, the offence, the subject of the proceedings, plead to the charge, exercise the right to challenge jurors, understand generally the nature of the proceedings as an inquiry into whether the person committed the offence for which they've been charged, follow the course of proceedings so as to understand what's going on in a general sense, understand. Sorry, I just saw a note for its mental health, the Mental Health Cognitive Impairment Forensic Provisions Act 2020. And so making a defence or answer to the charge, instruct the person's legal representatives so as to mount a defence and provide the person's version of the events, etc. What's important, so one is remember that the test is now codified and you can find it in section 36. And the other thing is when you're dealing with fitness isn't something that's either there or it's not. Sometimes it can change. Sometimes you can be representing someone and they're doing well, and maybe stress or others, like stress at the trial or other stresses, might impact on them, and it can start to affect fitness. So it's not something that's necessarily going to be obvious and there from the beginning. And there's a infamous case of males, which is if anyone ever reads, you'll see where, you know, the things that the defendant was or the accused was doing during the trial, and the judge rejected the issue of fitness, and that was obviously dealt with in the Court of Appeal. But it's something that can change over time. The other thing with fitness is there's a presumption of fitness. So the starting point is you are presumed fit. And so when this comes up too, what you'll see is experts need to be engaged, and there'll be an assessment done, and normally they'll address these criteria. And what will happen is there'll be then a fitness hearing, which is in the absence of a jury. It's just a judge hearing, and often it's uncontentious where the evidence is so clear and the experts agree. Following a fitness hearing, if the person is found unfit, and you'll hear probably more about this from Bernard, the speaker after me, about the Mental Health Review Tribunal and that process and how that all ties in. But normally what happens is after a fitness hearing, the person will then have a special hearing. Special hearings are normally done in the absence of a judge, although there is a subsection that says you can apply to have a jury, but it's normally done in the absence of the judge. It's normally done like on the papers, largely, although some witnesses are called, and then the judge will make a decision and they'll make a finding on what they articulated as a finding on the limited evidence available. And if the finding is that they are then found convicted, and then they'll receive a limiting term if they would have otherwise received a custodial sentence. And so what would then be expected to happen is the person would be kept in prison, or they could be held in the forensic hospital, or perhaps a medium secure unit. But often what happens is they're held in prison. Beds in the forensic hospital, if they had a mental illness, for example, are very, very tight, and there's a very large waiting list. So next slide, thanks, Mark. So the mental health defence is section 28, and that sets out there the test for the mental health defence, and now you have the new definition that ties in with that of mental health impairment or cognitive impairment. So if you assert this defence and you successful, then it's results in act proven but not criminally responsible, and then you're a forensic patient. Sorry, next slide. Thanks, Mark. So I'll just go through these quickly, and then obviously you can have access to the PowerPoint as well. So if you've missed any of the notes on one of the slides that you wanted to get. So once you become a forensic patient, where do you go? Well, often you go to prison, and what will happen is you'll be reviewed every 6 months in the ordinary course by the Mental Health Review Tribunal, and it's the forensic division of that tribunal. So it's usually a 3-member panel, and they'll make decisions about leave and release. And so normally what would happen is when it's time to working towards release, there'll be an intention filed, a document, and then there'll be an independent risk assessment report done. And then if the tribunal is satisfied on that report and there's no risk, then they'll make an order for conditional release. And then at some point, if you're not on a limiting term, at some point you may be unconditionally released. But with limiting terms now, and I think, sorry, next slide, Mark. With limiting terms now, what we're seeing is they're often involving an extension application in the Supreme Court. Now, these are different to, you may have heard high-risk offender applications. They relate to sentenced prisoners, so people still in detention or on parole, and those ones are where the state or the Attorney General applies to the Supreme Court for an extension of their detention in jail or their supervision orders, whereas these ones are people who are forensic patients with a limiting term about to expire. They may be in custody, they may be in the forensic hospital, or they may even be in the community on conditional release. And what happens is they make an application and seek an extension of the forensic status for up to 5 years. Initially, what happens is they'll file an interim application. It's all done on a very urgent basis, and they'll have a risk assessment report done. And at that hearing, the judge is required to look at the material filed and the risk assessment report and say, if I accept everything without evaluating the evidence, would this person be a risk of serious harm to others? And can that risk be adequately managed by other less restricted means? And if he's so satisfied that the person is an unacceptable risk and can't be managed in that other way, they'll make an interim order. The interim order is up to 3 months. And what happens then is the person is required to attend 2 separate experts, independent court-appointed experts, and they prepare reports for the final hearing. And then at the final hearing, they'll give evidence together in a conclave, so they'll sit in the same witness box, the experts, and questions will be asked, and the judge effectively can evaluate the evidence at that point, and they have to decide whether the person is an unacceptable risk of serious harm to others and whether or not they can be adequately managed by other less restrictive means. Now, unfortunately, in most cases, an order is made. It's not uncommon to see in some cases where an order might be made for 2 years and then the attorney comes back and makes another application. So there's no restriction on the number of applications that can be made. The other thing to note about this legislation, sorry, just went that thought, but the interplay too, sometimes you might have a forensic patient that's committed offences that would also make them subject to the Child Protection Offenders Registration Act and the Child Registration Act automatically once they're released. And they may then also be subject to the Child Protection Offenders Prohibition Orders Act, and that one relates to the Commissioner of Police making an application to the local court to put behaviour restrictions on the person. So they might, if they're a sex offender, forensic patient, and then they're conditionally released, they might be subject to review ongoing by the Mental Health Review Tribunal, and also subject to the first act, the Child Protection Offenders Registration Act, and possibly the second act. And so what I was going to say is only a few cases have been successful in challenging these orders, but the vast majority have resulted in an order being made. And the other thing to note is this legislation was introduced in 2014. And what has happened is a lot of people with cognitive impairment who may not have a comorbid mental illness or other reason to go to the forensic hospital or a mental health facility will sit in custody. And then if an extension order is made and they haven't been released, will remain in custody until they are conditionally released. And so it's really having a negative effect in a sense, because all of the experts will agree and say often that it doesn't assist having people sit in custody when they are cognitively impaired, and it can be deleterious. But it's a problem because it's quite a difficult test to get over to get conditional release in some cases. Next slide. Thanks, Mike. So reflections, I hope I'm sticking to the time limit. I guess, I mean, it's hard to think what topic in the short time to raise under this heading. But one of the things that has really frustrated me is in the context of those extension applications and seeing people, particularly people with cognitive impairment, remain in custody, in the process when we have these final hearings, we have experts. So the experts are usually forensic psychiatrists or psychologists, and they'll give their expert report, come and give evidence. As anyone who has been in court or seen these would know, what's happening is the courts play a huge amount of emphasis on these reports. And one of the issues is a lot of the risk assessment tools are being used in a way that's almost like risk prediction, which is what they're not meant to be used for. And in that, when you use risk assessment tools, you're not meant to use them where they're not validated for particular populations. And one of my frustrations has been, and trying to sort of raise it in appropriate cases with the judges and the experts, is to get them to acknowledge that the risk assessment tools being used are not validated for use in Aboriginal populations, Indigenous populations in Australia. And one of the anecdotes I wanted to share with you was just one of the cross-examinations it's all very friendly cross-examination, by the way, in this jurisdiction, but I just wanted to show you the sort of what's happening. So I asked the question of one of the expert psychiatrists as a separate question, basically asking about the validation of use in Indigenous populations. The answer was, again, I believe the HCR has been, but I'm not 100% certain, no. In saying that, in terms of your belief in that in relation to Australia, is that in relation to Australian Indigenous populations or overseas? It's an overseas instrument that's now used heavily in Australia. It's probably the most widely used instrument in Australia, but I'm certainly unaware if it's being used in Indigenous populations overseas. In Australia, I would have to review the evidence. So keep in mind, this is an expert that's written a report saying the person needs to have a continued order and is aware that the client identifies as Aboriginal, but hasn't come to court having reviewed that evidence or having an answer for the court about perhaps the limitations of the risk assessment. I go on to the other expert who was in this particular conclave, a psychologist, asking, in terms of those instruments on Indigenous populations, are you aware of any validation for each of those 4 risk assessment tools that you've used and referred to form your opinion of risk? The answer was, I'm aware of the HCR overseas there has been. I'm unaware of anything specific to Australia. And again, very similar, where they say that it can be used and that it's better than nothing. It's not as robust, I suppose, as a non-Indigenous group. I'm not sure about others in the audience, but that troubles me a little bit. And then going on, I asked another question saying, in terms of generally using risk assessment tools in Indigenous populations, were you aware the American Psychological Association did not recommend the use of those tools where there had been no prior validation? Witness, oh no, I'm not aware of that. So in Australia, is there anything similar to your knowledge? No, not the APS, which is the Australian Psychology Society. They don't provide any guidance around that. So I guess I just raised that as I raised the issue with the judge. Disappointingly, the judge didn't take it up. But my concern is that where there are sometimes multiple applications for people to be detained by way of an extension order, it's concerning given how much importance is placed on the experts that not enough questions are being asked, and perhaps other methods should be looked at, or perhaps this should be at least appropriately acknowledged in terms of their evidence, because what it effectively does is overinflate the risk, particularly where there has been past trauma. So that was my frustrating moment that I wanted to share with you all. But now I'll hand it over to you and invite questions.
Thanks so much for covering so much ground there, Corey. And those reflections on the cross-examination are just startling. And I'm no real expert, but I think the answers are no that you were seeking. And HCR and other things are validated possibly to some extent on Canadian First Nations groups and populations. But there have been judges, Justice McKechnie quite famously in the Supreme Court of Western Australia, saying that the static 99 should not be used as a risk assessment tool when trying to assess the risk of Indigenous Australians. So there are some judges who are quite strong on that. The fact that the mental health professionals are not necessarily knowing the literature is a little bit scary. So thank you for your cross-examination there. Open it up for questions for people. I again have been overstimulated myself with thoughts in my mind, but we do have a question in the chat. So thank you to Karina. I remember there was a hospital inside Long Bay Correctional Centre. Is this where forensic patients are held? And I think we've confirmed that, haven't we?
No, can I just?
No? Yeah, thanks.
That. So, Karina, no, there is a hospital, like a hospital, but the forensic hospital is separate. So there is a hospital at Long Bay, but it's inside Long Bay Correctional Centre or down. But the forensic hospital is totally separate. You'll know it. It's a great big massive building next to Justice Health Administration.
Yep.
Yeah.
Thanks for that. What's the alternative to using an unvalidated risk assessment tool? Grant is asking.
I mean, it's probably more a question for, the experts to say, but normally with these types of things, there's 2 types of things. They can use these tools and professional judgment. And structured professional judgment's obviously the combination of both, which is more robust. But I think the use of the tools is leading to perhaps overinflation and, therefore people spending more time in detention. So perhaps professional judgment, but perhaps a psychiatrist might have a better view than that.
And a great further question, how do you argue that someone is not an expert witness or not a good enough expert witness if they don't know the literature on some of the validation questions, Corey?
I think, well, in that context, I think it was accepted they were an expert for the purpose of what they had to comment on. But what I was trying to get the judge to do was to put less weight or limited weight on their opinion, because in this particular case, don't get me wrong, there are cases where they're so obvious, the offence is so obviously that have been committed, the person is a risk. But this particular case concerned me because the index offence that led this particular person into custody was like a robbery where other people in the group went inside the house and sort of hit someone and took their wallet. And my client stayed out. He had a significant cognitive impairment, stayed outside the front, but was charged with that high crime and found guilty on the basis of joint criminal enterprise. So, you know, even though you get punished the same, I felt his role, like his own evidence was, he told the police that I didn't want to go in, I didn't want to be involved in hurting them. I mean, I always question how he was actually found guilty of that one, but in any event, he was and received the limiting term. But he wasn't someone, he was very borderline in terms of, you know, needing that extra order, but the judge didn't, he didn't even address it. So
quite concerning, because the HCR is all about violent behaviour in a sense. Look, I was going to draw a line directly between Dr. McIntyre's presentation and yours, and that's where we had the voice of some people saying, look, if I knew what would happen to me if I claimed a defence, I wouldn't have claimed the defence, and I wouldn't possibly even have gone for an unfitness to plead sort of argument. And as you were speaking, I thought there seems to be more likelihood of being released from custody if you're a limiting term type of applicant or patient than if you had gone for the act proven not criminally responsible defence, until you started talking about the extension possibilities, which are really quite alarming as well. So I don't know whether you care to reflect on that in terms of what clients actually are worried about in terms of how their liberty is going to be curtailed over time with successfully claiming a act proven not criminally responsible argument versus maybe an unfitness to plead argument.
I mean, I couldn't agree more with what was in Dr. McIntyre's presentation. That is exactly what clients say, like all clients say, because often they're in custody, they speak to other people in custody and get some informal advice from other people in custody. But sometimes it feels like that they would have a more certain path if they did go down the, if it was a murder, for example, if they went down substantial impairment rather than, because they would be found guilty of manslaughter. They would then be a serious offender, so managed by SORC in custody in terms of classification. But ultimately, by the time it came up to their non-parole period, if they'd done everything, they would have more chance of getting out on parole at that time than via the other route. And I guess it also does depend too on what the person's condition is. For example, if it was serious mental illness only, and whether they were still so unwell that they needed to go via the forensic hospital or just remain in custody and be conditionally released from there, or whether it was cognitive impairment, for example. The only thing I have noticed in more recent times is NDIS. Sometimes people coming out on conditional release, they have an NDIS package and assistance too, which is good. But I think there is a sort of informal thing amongst criminal lawyers that it's better to be sentenced. It's better to be sentenced and raise mental illness on the sentence rather than to go down the other route.
Because that may still enable you to become a correctional patient if need be. Is that correct? You
could be, yes, but it's there's big delays in that too in custody.
Okay, yeah, fantastic. Well, look, there is quite a interesting question in the chat with a factual sort of example, and I might leave either Corey or Dr. McIntyre to answer that in the chat if you feel like you want to. But I think in the interest of time, we need to give everyone a break for 15 minutes or so. We will start Peter Ringbauer's presentation around about 11:05, if that sounds okay, and give you the full 15 minutes of a break now. But can we thank Corey for the presentation, and you've really taken us into the current Act, which has all sorts of really interesting modifications, the codification of presser. It still doesn't have a control limb or a volitional limb, for example, under Section 28 compared to other jurisdictions. There's still really interesting comparative work there. And thank you for laying all of that detail in front of us so expertly. And thank you for the work that you do in practice, obviously, in our connection with us today. So thank you.
Thank you, Mark, for inviting me.
Okay, so we'll see you at 11:15. Sorry, 11:05. 11:05. Okay, thank you.
Yeah, stand the phone. Yeah. Can you hear me on the audio there? Okay.
Yeah, I can. Yeah.
Yep. Okay. That's good to go then. Yep. Hmm.